Ever wondered how a country can simply give up its rights in international disputes, intentionally or by accident? Imagine losing your claim to territory just because you stayed silent or acted the wrong way. Today, we dive deep into a concept that could change the outcome of global legal battles, the doctrine of waiver in international law. Welcome to Law Ignite. If you're passionate about law and justice, hit like and subscribe now, because you won't want to miss the legal truths we uncover here. The doctrine of waiver is a principle in international law where a state voluntarily relinquishes a legal right, claim, or privilege, either expressly or by conduct. This means that inaction, delay, or specific behavior can result in the loss of entitlement, even against another state. A waiver doesn't happen automatically. There must be a clear intent or conduct so inconsistent with the assertion of the right that the other party can reasonably rely on the assumption that it's been abandoned. An express waiver involves direct, written, or oral statements relinquishing the right. An implied waiver happens when the right is waived by conduct, like silence, omission, or acquiescence over time. In the Temple of Preah Vihear case, Cambodia versus Thailand, Thailand's failure to promptly contest a map and its long-term acceptance was interpreted as tacit acceptance or implied waiver of Cambodia's sovereignty over the temple. States sometimes lose claims to territory because their actions, or lack thereof, demonstrated they wouldn't enforce their rights. But what happens if a state regrets its silence? Can you ever reclaim a right once it's been waived? Stick around for the answer, and you'll realize just how high the stakes are in international relations. Clear and unequivocal, the state's intention to waive must be unmistakable. Knowledge, the state must be aware of the right it is waiving. Voluntary, the decision cannot result from coercion or undue pressure. International responsibility, waivers affect the responsibility of states and the ability to pursue claims in international tribunals. Can all rights be waived? Fundamental human rights and certain jus cogens, or peremptory norms, cannot be waived by states, as they form the core of international obligations. Undoing a waiver is extremely difficult, often impossible. Once a waiver is established in conduct or communication, it is legally binding, unless all parties consent to revive the right. International courts heavily scrutinize state behavior and evidence. So the next time you hear about a country staying quiet in a dispute, remember, in international law, silence is never just silence. It could reshape borders, end claims, and decide nations' futures. If you found today's insight crucial, smash that like button, subscribe to Law Ignite, and ring the bell for more legal deep dives. What international legal doctrine should we break down next? Drop your suggestions in the comments below. Thanks for watching. See you in the next video.